All right, good morning, master brokers and our friends from City National Bank. I'm Jason Raymond, your executive director, and welcome to our first ever Flash Forum. We envision these 30-minute Zoom-based meetings to be opportunities for quickly exploring new and breaking topics that impact South Florida real estate. Forgive me if I stop from time to time. I'm admitting people into the room as we speak. Regarding new and breaking topics that impact South Florida real estate, obviously, this would include the new condo legislation that Governor DeSantis signed last week. So, we have reached out to condo attorney extraordinaire Russell Jacobs to tell us everything we need to know and how it will affect your business. If you attended either of our in-person discussions that we held last year regarding the new realities of older condos, you may remember we had one in Coral Gables, we had one in Fort Lauderdale. Then you'll remember Russell as one of our esteemed panelists. He brings more than 25 years of experience serving as legal counsel to a variety of companies and commercial entities. His firm is dedicated to real estate transactions, title, litigation, corporate work, and the representation of numerous condo associations. Russell also provides continuing education credits to realtors on contracts and other critical issues and has been named Educator of the Year by Miami Realtors. Before I turn it over to Russell, a couple housekeeping notes. We invite you to use Zoom's chat feature to type in any and all questions that come up during the course of his presentation. We're really hoping to keep this to a tight 30 minutes, so he will try to get to your questions once he's finished presenting. And in the interest of time, we have muted all participants. Please note that today's Flash Forum is being recorded and will be posted on our YouTube. With that, Russell, please take it away.
Okay, we'll try that again. This is Russell Jacobs. Hello and welcome and good morning to Master Brokers. Thank you, Jason. I appreciate the warm introduction. This is a flash forum, so we're going to be super tight with time and try to give you value and information in the first, say, 15 minutes or so, and then maybe 20, and then we're going to move to Q&A, so you have a chance to do that. If you're watching a recording, we're going to read out the questions. Only the good ones, and then we'll go ahead and respond to them so that you get a full flavor of what's going on. So let's dive right in if we can. I don't know how many of you know House Bill 913, as it was affectionately called. Some people called it Condo 3.0. I'm not sure why. Every year they amend the condo statute. This year was no exception. And the governor signed it last Monday on June 23rd. And today is July 1st, and it goes into effect today. So there was plenty of time for everybody to digest this thing and figure it out. So I'm going to walk you through. There is a ton of information. This bill was 92 pages long. Thankfully for you, you don't have to read 92 pages. I read the 92 pages, and I took out all the stuff about managers and about condo owners and everything else. And I have focused this conversation on the 5 things you as a master broker need to know and to help your clients and maybe to further your business opportunities and be aware of. So that is what we're going to focus on today. And it is effective July 1, 2025. So you are there. The first thing I want to talk about is the association website, and I'm going to explain why in a second. It used to be that only condo associations with 150 units had to be on a website. Last year's statute changed it to 25 or more. That's finally getting moving, and the association is starting to do that. Why is that important to you? The website, the new law now has new things that the website has to have. So the website has to have their bank statements. For example, all the association's bank statements need to be on there. They have to have unit owner ledgers on there, which is interesting. You actually get to see all your neighbors and what they owe, but that's good for you as a broker to understand what this unit does or doesn't owe or what's going to be coming up. Are there special assessments and things like that? So this is a whole new opportunity for you to be able to do a little bit more research if, for example, you're on the listing side or if you're on the buyer side. don't know why we keep getting muted. I don't know what you heard last, but essentially the concept is to be able to see what's going on and recognize the information that's available. But you now will be able to see bank statements and meeting minutes, and you will now be able to see unit ledgers. So this could be a very, very important thing for you to do. Why is this important on the listing side? Disclose, disclose, disclose. Remember, everything you disclose up front to a buyer during the inspection period is like an immunization shot from them being able to sue later on. You certainly don't want to get sued. Your broker doesn't want to get sued. You don't want your client to get sued because then you're a witness. And so the more you disclose as a listing agent up front, and the more your client discloses as a seller, the more immunized you are from a lawsuit later on. That it's Miami and Broward, so everybody sues everything for everybody everywhere all the time. But that lawsuit really won't go very far if you're like, look, here's the disclosure. Here's where we told you this. Here's where we told you that. So that is number one and key. So vendor contracts are on there. You can get your governing documents on there. So if somebody's missing their bylaws, their declaration, their rules, their FAQs, all that's available. Their insurance policies are on there, which could be really helpful to you. So all that stuff is available on the website now, and now is available in condos over 25. Okay. Number two, the biggest thing now is that there was a whole issue as to whether or not owner meetings could be on Zoom. They finished that. Now owner meetings can be on Zoom. There was a question about that. That's not a question anymore. And here's the fun part for you. All meetings must be recorded that are on Zoom and must be available to all owners within a year. Why is that important? Again, if you have a buyer that's interested in this condo and wants to know more, you can then link them up to the meetings that they've had for the last year and let your buyer scroll through them and look through them. If something comes up or they're not aware of something or they would claim you're not aware of something, this is a chance for them to see what's really going on inside the association, and they probably won't look at it. But if you gave it to them, then that's up to them to look at it or not look at it. So really important. This is going to be really bad for condos generally because you know what people say at meetings. It gets insane in there, and all that's going to be recorded. So I actually think this is going to be great for litigators. There's going to be lots more lawsuits, which I know everybody loves. But for you, this is really a disclosure issue and really understanding how a condo works from the inside out before potentially you market it to others. It'll tell you how many meetings there were and what happened at those meetings, and you don't have to ask anybody else because it's available. Item number three is insurance. This is a big deal, and this actually may lower maintenance fees this year. So it's something you may want to use as a marketing technique in your business. Insurance rates were skyrocketing through the roof, and they were getting kind of out of control. Luckily for us, the reinsurance market stepped back in, and so they were able to start kind of putting that back together. Insurance rates actually started dropping this year. This new rule in the new law is now going to have effect and helpful. It used to be that people interpreted the new law to say that all insurance for the association had to be at replacement cost. So think about if you have a 75 or an 80 or $120 million building, you have to get $120 million worth of windstorm insurance. You know how expensive $120 million worth of windstorm insurance is? It's crazy. What they have now clarified this year, just now, is that you don't actually have to get the entire building covered. You just have to do a study called maximum probable loss. That is exactly what you think it means. It's what is the most likely maximum loss someone's going to have. And in this case, they made it a 250-year windstorm event. So you have to think like, what's the worst hurricane you've had in 250 years? Probably down here in Miami, it'd be Andrew, right, in 92. If any of you remember that, or am I dating myself? And so ultimately, you have a 250-year event. That could be Andrew. How much damage did that cause? The insurance agents do a model, and then they tell you how much insurance you need to have. If your building is built of concrete and has a relatively new roof and impact windows, this is less of an issue. There was a whole other discussion we could get into on last year's law about impact windows and how associations can do that and whether or not they approved it, but many associations were moving to impact windows. If you're doing new condos, they damn well better be impact windows at this point, but that's obviously something you want to check because that will help keep insurance rates low, which keeps maintenance fees low, which makes the unit more sellable and more marketable as a low insurance rate. So That is certainly one thing. Number four, and this is going to be huge for you later. Not so much now, but I just want to make you aware of it so you can start looking out for it because this is going to be immensely helpful to you as realtors once this gets into place. And that is the DBPR, the Department of Business Professional Regulation, the agency you know and love that regulates you and your license, also regulates condominiums. And so in that process, last year they just asked for the name of the condo, the number of units, and they were just keeping it for information. Now, this statute expands that. And from now on, every time that there's a change in what the condo does, they have to report it within 30 days. And what am I talking about? They're asking for the basics like the name of the condo, the number of units, the email and phone number for the management association, how you reach them, which is, obviously good information for you. How about this? The age of each building, which is really great for you to understand what's going on, whether or not they've done a milestone or a structural integrity review study, an SIRS. Okay. This is one of my favorite ones for you as brokers. They will also now have to indicate whether or not there's a special assessment for the current year, and if so, how much. So what that does for you is you no longer have to take anybody's word for it as a buyer's broker. If you're a seller's agent and having trouble reaching anybody, this BBR database, once it gets up and running, will now have everybody has to post the assessments that they have presently in the building. So if you had trouble getting a hold of people, if you are in a rush or you can't do it, eventually this DBPR database is publicly available. It isn't there yet, but it will be. It will also tell you whether they've commenced construction in the last year, which is amazing. And so you will be able to have all that information at your fingertips. Once the DBPR database is established, they just expanded this today. It started today on July 1st, 2025. So you're going to have to give it a little bit of time for them to get it together. It's going to take a while for associations to get used to doing it. But you give it a year or two and things should start rolling through. And then what you're going to want to do is get access to that. They're also going to have a list of buildings that they deem unsafe. If you're into the space of terminations, some of you may be doing that. That's a really lucrative area for agents to get into, which is working to terminate buildings. It's a lot of commission, a lot of opportunity in that space, and a lot of the older buildings are going through that now. That's probably the subject of a separate conversation we could have and maybe a flash forum or something else. But because I'm going to run out of time in this flash forum, I'm not going to do that. If you do have other topics that you're interested in, you can put them in the chat. You can let Jason know, and we will come back to do some of those talks. Number 5 is the whole expansion of a milestone inspection. So just to be clear, for those of you who may not have heard my talk last year, you have a couple of new things that associations have had to do, right? You have a structural integrity reserve study that's checking your structure, your roof, your windows, all the things that affect the structure and making sure that condos are starting to reserve for them. That was due last year, December 31st, 2024. So it was due by January 1, 2025. They have now moved that to December 31st, 2025. So they kicked down the can down the road for people that didn't do it, and they can get their SIRS done by the end of December. If a milestone inspection was due at the same time, that's the actual, so the SIRS was the reserve study to figure out how much reserves the association needs and then start collecting them in case something breaks down. A milestone inspection is the actual inspection of the engineer every 10 years, basically starting at 30 buildings, 30 or 25 years old. And then every 10 years after that, it's checking the actual structure to make sure that it is okay. And if it's not okay, what needs to get done. Down here in South Florida, you would think of it like a 40-year recertification. All that's happened with Miami-Dade and Broward is that they've shifted their 40-year recerts down to 30-year recerts, right? And it's basically the same concept. If the milestone inspection happens at the same time as your SIRS, they are postponing your milestone inspection to be done in 2 years from now. And the reason that they're doing that is because they expect condo associations to be taking on all this work right now. And the expectation is that it won't take them more than 2 years. Ha ha, they don't know how condos work. It's going to take them longer than that to get that done. So they were trying to basically help alleviate some of the burden. I don't think it's going to work. And I think the crash we're seeing in the condo market is going to continue. I think this is too little too late to solve that problem. You will see as you go how it goes. The milestone inspection is 25 to 30 years, 25 if it's within 3 miles of the coastline, 30 years of age if it's out of 3 miles of the coastline, and then inspections every 10 years. So those are the different types of things that you need to focus on. And I can get into more detail if there's Q&A on that. I'm happy to do that. Here is the big change for you. There forever and ever and ever, as long as you've ever known it, there's a 3-day right of rescission for condo docs. You always remember that disclosure at the end of your condo rider. In the as is 7, it was in paragraph subparagraph 5 of the condo rider, where you pick A or B, and usually you pick B, where everybody gets all the condo docs and they have 3 business days to review it in order to decide whether they want to get in or out. And no matter what else you said in the contract, they get those 3 business days. So if you don't give them the condo documents until 3 days before closing and they don't like something in the condo docs, then at the closing, they could have gotten out. Well, that number has now changed. Effective today, that new number is 7. Okay, so you now have 7 business days. Buyers have 7 business days in a condo to review the documents, and they can get out for any reason or no reason if they don't like them. So, what are you going to do? As listing agents, you want to make sure that you get them the full set of condo docs and they sign off on a receipt, like probably as part of the contract, right? Because most of your inspection periods are at least 7 days, sometimes they're less. So you want to get that day for the condo rolling right when the contract's getting signed. You might even consider having it available so that you get it done before the contract is signed, so the 7 days has begin to run as fast as it possibly can. The minute that contract is executed, it goes, right? So this is very, very, very key. This is a massive shift in how you treat things. It's a 7-day shift from a 3-day shift. And obviously, for buyers, brokers, you're not going to say anything. You are not going to push them to do anything, because ultimately that may be your saving grace. If someone doesn't get financing or something else happens, they now have this 7-day period. So as a buyer's broker, obviously you don't want them to get out of a deal, but if you need to do something, you're going to want to do that. This is a very, very big shift. You'll get used to it pretty quickly, but it's something that's important. Don't have a lot of time because it's a flash forum. But I just want to point out that you know that the condo writer now has these 3 new check boxes where you have to talk about the milestone inspection, the turnover inspection, and the structural integrity reserve study, the SIRS. If we want to do a quick flash form, we could do it in 10 or 15 minutes where I explain how you figure out what box to check. I am happy to do that for you, because this has been confusing a lot of brokers and realtors in terms of what they check and how they check it and what happens. So we can certainly do that next time. But because I have taken unbelievably 20 minutes having the conversation I've had, I want to leave room for Q&A, and I want to keep this a flash forum. But if you do like these topics, or you want more flash forums on these issues, and you want to take a micro issue and blow it up and have a conversation on it, you can reach out to Jason, and I'm sure we can schedule another flash forum. So at this point, what I'd like to do is do Q&A, if that's okay, Jason. And because we have this recorded, I'm going to read the Q&A out, and then we'll go through it as part of the process. And this way, people on the recording can see what's going on. And you can raise your virtual hand, but I think it might be easier to do it in the chat if you're able to do that. Can you get a copy of this recorded meeting? Absolutely, you can. I will have this PowerPoint available if you provide Jason has your email, so if you give him the okay, I can send you a copy of the PowerPoint. We're happy to do that for you. It also has my contact information on it. Let me just make sure I put that up. So whoops. So you have that while we're doing our Q&A. Will you be able to get a copy? Yes, it's going to be mailed. I spoke about max loss, max probable loss. Is there any indication that lenders, let me see where I have that, will still require replacement costs? The law says max probable loss, so lenders can do whatever the hell they want to do whenever the hell they want to do it. Most of them generally tend to accept Florida statute, and lenders were consulted in the process. Don't think that anything gets through the legislature without the lenders lobby having a say in it. So very likely that was there. Does forwarding the website have all the documents sufficient for receipt of documents? It's supposed to. Okay. If you go back and look at the disclosures of what's required, it's the declaration, right? It's the bylaws, the articles, right? It's the rules and regulations. It's the FAQ, the frequently asked questions and answers. It's the budget and the annual audit. Okay. How many associations have their FAQ? Almost none of them. Okay. They just don't have them. And so the next question is what happens if the docs say FAQ and they don't provide it? Ultimately, there is an FAQ that was provided at some point, even if that goes all the way back to the developer when they sold the units originally, it is out there. So one of the things that you need to do is harp on the association to either get better lawyers or get better managers or get it done. But ultimately, there is an FAQ that's out there. It's just a question of whether it's stale or not. And associations are supposed to update those FAQs every year. Can the 7 days be waived to end earlier? Only if they receive the documents earlier. So you could checkbox 5A, right, and say I've received the documents, right, and that could be done earlier, maybe even before your contract got signed. Or you could give it to them earlier and then make them checkbox 5A, which says, hey, I already got the documents and I already reviewed them. That would be a way to waive it. That's the only way basically to waive it because ultimately at the end of the day, there is no other waiver. But if they acknowledge and sign off that they got them and you did give it to them, then they can say that they got them and then there won't be a 7 day period to review them. That's it. If I attach the condo disclosure with my listing in the MLS, is that enough? As a lawyer, I would tell you nothing is ever enough, and there'll always be a litigator that can find something you did wrong. We are in South Florida after all, so there's where we are. The goal is to try and do as much as you can to reduce it. So a disclosure in the MLS is helpful. What I like to do in my condo writers is I put in that the buyer is responsible for asking the association anything it wants and will go to the association directly, and the seller will cooperate with the buyer to get any information they want. And then we can offer to give the buyer access to the website, which has the information and access to management. Once you do that, if they don't avail themselves of it and they never email you back and be like, I need that information, then I think they're going to have a tough climb later on. On the website, how often does that have to be updated? The new rule effective July 1, 2025 is that within 30 days of a change, within 30 days of an additional document, those websites now have to be updated. So that is really, really critical. It's going to take time for associations to recognize this. It's going to take time for them to do it, but it's really, 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 really important.
Russell, can I just jump in for 1 second? Because we're getting a lot of questions and requests about getting a copy of the PowerPoint and or a full recording of this presentation. I want to let everyone know that yes, we will be emailing all members a copy of the PowerPoint itself and a link to see this recording in its entirety. So no concerns there.
Super. And with the few minutes that I have left, I'm going to continue to ask questions. And if necessary, we can always go over for people that are willing to go over and stay. And I will keep answering questions about this or anything related to real estate you want to make sure you get value out of the presentation, but you're not obligated to stay. This is a great question, and I think this is probably the one that plagues most of you now, which is under the new condo writer that has those 3 check boxes. Okay. The question is, do you have to ask each association, and by law, do they have to tell you? And the answer is yes, they're actually required to produce this now on their website. So they have to give that information to the seller. Some of them play games and they're going to say, well, you're not an owner, so I can't give it to you, which is why under contract, your seller has to give it and your seller has to go back to get that information. If you're the listing agent, then you're going to need to push them to do that. The check boxes are one that the listing agent is supposed to complete for the transaction, or you can try to get management to complete it. But I have to tell you, most of the managers don't even understand this stuff. So Jason, one thing we might consider is a minor or smaller flash forum on those three checkboxes where I can train you and teach you how you figure this out and how to do it. Once you get to the place where that the DBR reporting that I described is up and running and is in more full-fledged, you'll be actually be able to get those answers right from what they've given to the DBPR because you'll know whether they have a milestone. You'll know whether they have an SIRS. You'll know whether there's special assessments. You'll know whether there's ongoing construction. And you'll know how old the building is, so you'll have a sense of when turnover occurred. So a lot of this will become obvious. There's some cheating ways to figure out some of this. And again, we just don't have time today to go into it. So if you want to do that, we can certainly do that at a different time. Will Fannie Mae, Freddie Mac, FHLMC accept the new Florida law with respects to wind coverage? Again, they had to be involved in the legislative process. I can't imagine that they weren't. So we certainly would hope so. It's not a huge change, and it's not really, there's not that much risk to the lenders if you're thinking about it. When you think about the worst damage that can occur in 250 years, and you're insuring for that, the percentage risk is super minor. So some lenders may not take it. It would seem like they would have checked with Fannie Mae and Freddie Mac before they put that into place, but it is the Florida legislature, so who can say? Let's see. We talked about the check marks. So condos with 24 units less do not need to have a website. Correct. At this moment, 24 units and less do not have to have a website. They still have to report to the DPR. So eventually you will get that information, but right now you will not. Okay. So when I refer to the condo website or Dade County registration or both, I'm not referring to Miami-Dade condos registration site. I'm referring to the new requirement for the DBPR to have a statewide registration process that they have, that they now have all these new requirements. On the addendum, was there a change on the payment of special assessments? I don't have the addendum up in front of me, so I did not memorize that, but ultimately, special assessments are the obligations when their boards still have the right to decide whether they're payable in full at a closing or not. And as always, those are still points of negotiation between a buyer and a seller. So regardless of what the condo writer says about special assessments, you know what the market looks like, you know what your special assessments look like, and so you know ultimately whether or not it's going to work for you and your buyer and your seller and what you need to negotiate. I am at the 11:30 mark. So Jason, I want to thank you for the opportunity to speak to everybody. I am willing to stay on if you have questions about this or anything else related to real estate if you like. And we can have a more informal chat if you want to do that. So if anybody has any questions about this or anything related to real estate, I'm certainly happy to answer it. I'm Russ Jacobs. You're also welcome to reach out to me individually if that's helpful to you. If you're in contract prior to July 1, but not yet closed, do we need any of these addendum to existing contract offers? The answer is that this is effective as of today. So if you're in the middle of a contract, you may need to go back and revise. Most of the biggest issue that you would have in your contract at this point is the 3 versus the 7 days. So if your 3 days already passed, and in fact 7 days already passed, you've done what you needed to do. And so the actual time frame has been given. If you haven't done that or you just signed the contract yesterday, you're going to need to give them 7 days. Can they get out because the contract doesn't say 7 days, even if you actually gave them 7 days? I don't think so because it's a disclosure, but obviously, because today is the first day of the statute, no one's had a chance to sue yet. So I guess we'll find out. Any other questions that anybody else has at all about this or real estate or anything else? Okay.
Well, Russell, thank you on behalf of Master Brokers. We really appreciate your incredible time and insight. If anyone would like to stay on and keep posting questions in the chat, Russell will be happy to answer them. But for now, if you have other things to do, you can jump off the chat or jump off the Zoom. And this was amazing. We had 96 people at our peak during this flash forum. So obviously, there's an interest in this topic. Master Brokers, we included Russell's contact information in the chat, and it's there on the screen now. So you can reach out to him directly or reach out to us at info@masterbrokersforum.com and we'll make sure that it gets to him. Before I sign off, want to wish a very happy birthday to our own Rich Campanella, our liaison from City National Bank, and would remind members that City National is our amazing financial services partner for all your mortgage needs. Please reach out to Rich for anything that you might need. So we hope you have enjoyed this first ever Flash Forum. Please continue sending questions if you have anything. But if you'd like to sign off now, you're all set.
And I'm just going to say there's a couple of questions that I think are really helpful. There's one by Adam Prince that I don't understand. I'd like maybe you could unmute and we could talk it through. It's what is the clause you use on the condo writer for the buyer? So I want to understand that question a little bit better. So Adam, maybe you can unmute and we can have a little bit of a discussion about that. I think it's one that people are probably going to want answers to.
Yes,
If
thank you.
Adam's the one.
Yep, thank you. I was just asking, you said that you normally put on your condo rider that it's the buyer's responsibility to, and I was just wondering what that
That is?
to do their own due diligence or
Right. So you have two parts of the condo writer where there are blank lines in paragraph 3. You have paragraph 3C1, which talks about special assessments, and you have paragraph 3D, which refers to litigation. Because as a seller, I don't know what the buyer is going to want or not want. As a selling side, as the listing agent, I want to say in those blank lines, the buyer will reach the condo association, will inquire with the condo association, and will inquire about any information they wish to have, and the seller will cooperate with the buyer to help them gain access. That is what I say in those two blank lines. And what I do there is I'm trying to shift the responsibility from the seller to the buyer side. And you want to know something? I don't know what you want to know. Go ask whatever you want to ask. It's an open book. I don't want to hide anything from you. I just don't know what you want to know, right? So at the end of the day, they can go do that. And then we would set up a way in which the seller can help get them access. Because if some of the condo associations get cute and they don't want to give a buyer any information, even though statutorily it's actually required, then the end run to that is that the owner gives them access themselves. So in the case of over 25 units, there's usually a website. There's an opportunity to speak with the manager sometimes. And soon there'll be this DBPR information. But ultimately, you want, as the listing agent, you want to push it off to the buyer. Obviously, as the buyer's agent, you want to go in the other direction. So you don't want that clause in there at all. You want to just insist that the seller cooperate and provide you the disclosure and insist that you haven't gotten the information that you need to get. And from the buyer side, there's a lot of information that they don't normally give. You don't normally get the audit, right? They're usually a couple years behind on the audit. So you can use things like the audit and the budget and the frequently asked questions and answers, which are very difficult for the seller to get, to muscle them into getting you what you need and saying that they haven't completed their rescission. And so the contract is still up for grabs. Obviously, you don't want to cancel the contract. You just want to get the information together. So hopefully, Adam, that answered your question.
yes, thank you very much.
Oh, my pleasure. Does this affect HOAs? There is the scantest mention of HOAs and co-ops. Actually, a lot more on co-ops than there were on HOAs. The insurance issue, for example, was addressed for HOAs, but ultimately that statute was left pretty much as it was without a lot of this information. For whatever reason, the DBPR has always taken, the legislature has always taken the position that if you're in an HOA, not a condo, you don't really need the same protection. So they really only get involved in very limited circumstances, like, for example, with elections. But day-to-day disclosures and things like that, you'll notice that your rider for an HOA doesn't even mandate that the owner give you anything. Like, you don't have a right of rescission. It's just really, really, really super bare. Oh, you had somebody jump in there. Do they also change the structure from 3 to 4 floors? Not that I saw. I had to read 92 pages in a very short period of time. I didn't see anything with a change to the 4th floor. It looks like it's still, 3 floors and up. It's actually 3 floors and up, so 3 floors still count. But I did not I did not see that. I'm happy to go back and weed back through, as I will be doing, because I now have to give another presentation to condo associations I represent on what they have to do, which is a lot longer than your flash forum for realtors, because there is a ton of new things for condos that they have to observe. But I didn't feel like they were super hot points that you as a realtor or broker must have in order to do your job and get a deal closed. So there, but there's a ton of, I mean, it's 92 pages. It's a lot of changes. But I did not see that. Are there any other questions? Okay. Well, in that case, my information's on the screen. Jason, I just want to say thank you for allowing us the opportunity to speak. Hopefully, all the brokers on this meeting got something out of this. You got quick value in an intense time period. No fluff, just information, which is what we were trying to go for on these flash forums. If you liked it, let Jason know. And you got a new topic you want me to cover or you want someone else to cover, let Jason know. We're excited to do them because ultimately there are, how many agents are there now? Like 63,000 agents in South Florida at this point. What separates you from everybody else? I think it's developing trust. And I think when you develop trust, it's through information. When you can educate your possible prospective clients on why you're good at what you do and why you know more than every other agent that does that, that's going to lead to more referrals. And word of mouth referrals is the name of the game in South Florida. It's how you get more business. So hopefully that's what this did for you. If it didn't, we accept critical feedback also. But either way, we want to be helpful to you. So thank you for that.
Absolutely. So, yeah, we hope this adds to your current value of your master broker membership. That is the idea behind it. So, with that, we're going to close out this flash forum and wish everybody a great rest of your day. Feel free to reach out to Russ or myself, and we will get back to you as soon as we can. Have a great day, everybody. Thank you.
Thank you.